Right, so this is, I don't know if I can even call this discovery request, because it's not completely discovery. Do you discover mental illness? Do you discover alibis? Doesn't really sound like that. It sounds more like they're prodding a plea more than anything. And my prosecutor's done it twice here. This was the first one back in 2022. And Cloyd writes this formal discovery after I filed my discovery. So this is more of a response he's making, and it appears the law really supports prosecution's approach as equally as defenses. They really don't respect your Fourth Amendment rights. So they demand it, and the judge can. There's punishment I have listed at the bottom. The judge can follow through with it. I was threatened in court multiple times about having to surrender evidence. And I had to say multiple times I don't have any evidence. But it's more than just that. And Cloyd has the option to mention whatever he wants in his reciprocal. This is a reciprocal discovery request, because the law says if the defense requests the discovery, then the prosecutor has a right to discovery themselves. Unfortunately, though, Cloyd can't give all the discovery, and he gave it piecemeal with what he wanted to give, but on top of that, he just flat out didn't give any, and this was supported by the librarians, because the librarians had to cover themselves up with the false reporting, and held back 2 library witnesses and video, the surveillance video. They made sure to delete it right at 30 days so they didn't violate any policies. To avoid any embarrassments, they deleted those videos. So this is the first one in white. This is the second one, and I asked ChatGPT, what differences do you see between these requests? And it looks like I have connection to Wi-Fi, so I could do that right now. Alright, I'm just going to copy both. We'll just keep the case. The ChatGPT doesn't mind. Alright. ChatGPT's on my main home screen now. Okay, yeah, I asked about fondue. Alright, let's see. I want to go to the top and just ask, what differences do you see between the 2 discovery requests? Simple question. Wait, how long do I have to wait? Oh man, this could take forever. Thinking. I'm still connected. I don't have much of a connection. So I put in 2 requests for discovery. They're demands, actually. I think he said demand. Let's see, no. Moves, oh, he moves. Moves the court. Okay, it's not really a demand. Alright, so maybe it's not going to work. I thought just because I had a connection it was network error. Well, I'm not going through ChatGPT then. Okay. Wow, I was pretty confident that was going to work. Well, I saw that, I checked it previously and it said something about, in the second one, Cloyd asked for, let's see, written mental disease. No. It's right before that then. Case in chief. It was expert stuff. Discovery without all books. It said something about this connection experts. So he mentioned experts, which wasn't mentioned in the first one. And I thought the law may have changed since my arrest. It's been a couple of years now. But that the experts request is a part of a change that happened back in 2013 with that law. But when you look up Article 725, you get the 2013 version, which is like a couple of years before the change. You get all kinds of smatterings of change of years when you check out these laws. But in the second one, he has to prod me with mental diseases and alibis. Those are my ways out. And I was curious about the alibi. I asked ChatGPT, what is a good alibi? Using witness statements, library records, surveillance footage. I couldn't use, I guess if I wanted to pursue an alibi of surveillance footage, the library made an effort to delete their library footage. Can they tie me to the library with any books I checked out? So they delete evidence to cover their own butts, but it makes it harder for them to prove I was at the library because they deleted the surveillance footage. As far as I understand, with the string of emails that you see. All right, I got emails in the, let's see. So how do you know, what are these people thinking? All right. It was just a simple request. So they want to delete evidence. Yeah, Jessica McGrath is the one that approved it. They want to delete evidence, and their priority is to protect themselves, but also they weaken their case, and then requesting permission to delete video from 30 days prior. So they were on top of that. They don't do that every month. The chances of them doing that every month are very slim. Why would they be doing that? They just were unsure of my situation, and there's a ton of white space. Wherever there's white space, you can pretty much assume there's a redaction. They don't even want to spell Jessica's full name in that one email. So that's unfortunate. To take out that surveillance footage, and it's not like this is an isolated incident, because this same thing happens with the another guy. I think I got his name. Nope, it's not on the front. Let's see. It might be Campos. Oh yeah, it happened with Campos, where the investigator, Jessica Williams, she was just like, "Oops, it's gone." I don't think it was exhibits at the trial. I saw it. It's one of these. I don't think it's exhibits though, because it happened after his trial. Oh yeah, the pictures of the off his camera. They stole his camera to grab pictures from it. So yeah, that's you know, that's clearly they're making the evidence at that library, but it was deleted. And well, let me just go right to it. All right, this is in yellow. I can come back to the yellow. I put it in red. It's right here. Mistrial on motion of defendant. That's grounds for a mistrial, because I requested that library footage, and then they delete it. That's mistrialable under this law. To delete the library records. Okay, timestamps digital. If you were using a personal device, so my device could link me to the area, because I did turn on my devices, phone and stuff, get on their Wi-Fi. Detailed timeline. So I mean, the alibi links me to the library. Alibi, mental state, if applicable, support your defense. So under my alibi question, they talk about mental state. Was I mentally there? I guess that's part of the alibi. I don't think the cops were in their right state of mind. All right. Article 725, reports of examinations and tests. The court can grant relief. Let's see. They want to do... This is where you get experts made in connection with a particular case that are in possession, custody. So that's the thing. The defense just has to know there's material out there. Well, I'll tell you what. I know that there was... I would reveal that there was a library video based upon the evidence of the librarians openly admitting, well, through public records requests, admitting that they deleted that video. So that's evidence that was deleted, and it was requested. So where does it say that? Experts disclose to the state and permit or authorize the state or an expert. So Cloyd could appoint an expert to receive this evidence. He doesn't have to pick it up himself. He could just declare that somebody is an expert with the state, and they serve as the person who can pick up this stuff. Any results, examination, scientific, let's see, possession. that are in the possession, custody, control, or knowledge. See, that's the thing, or knowledge of the defendant. Well, we have knowledge that there's a library video that was deleted, but like, where is there any chance of recovery? All right, that's what I'd like to know. Is there a chance of recovery? We have knowledge of that, so I think that should be disclosed in some way. The prosecutor didn't disclose it for my trial. They totally brushed over the fact that there was library surveillance video. But wow, all the trolls were on me about recording in the library, thinking I recorded inside. And once they were comfortable that I didn't record walking around, then they were comfortable deleting the library video. Disclosure by the defendant, names of defense witnesses. They want the date of birth of the witnesses, and that's a part of the law. So all witnesses need to give their dates of birth, and even their FBI profiles too. We're allowed to see their FBI profiles. That's a part of the law. So that's let's see, Justia, I don't know, I don't know if I want to go to previous. I have no internet anyway. So that's a part of the law. Getting their birthdays, and I'm guessing since it's a part of the law, you could just, ask them their birthday as a part of the record at court too. I mean, look at that. They talk about privacy, and date of births are a privacy issue, yet they're privy to the date of births for themselves, and that's for the prosecution. But they could threaten to arrest, to charge me with a crime for disclosing somebody's birthday, but it doesn't work the same way for the prosecutor receiving the date of birth, birthday, date of birth. If I move for disclosure of statements of witnesses to be called, wait a second, if the defendant moves for disclosure of statements of witnesses to be called by the state, the defense shall, upon motion by the state, disclose to the district attorney and permit or authorize district attorney to inspect recorded statements of any witness the defendant intends to call at trial. Okay, yeah, it's it's tough to be a defendant. All right, you can't. There's nothing you can hide legally. You could be held as a crime. You could be charged with a crime for withholding any information. You even have to just have knowledge. So what do? I want to respond and say, yes, we have knowledge of this library surveillance video, and make that clear, make that a part of the discussion. So there's the insanity. Yeah, okay, so this is the law. They talk about your mental condition. If the defendant intends to introduce testimony relating to mental disease, they didn't have the mental risk state required for the offense charge. You got to let the prosecutor know in 10 days. Let's see, if there's a failure to give notice, the court may exclude it. And as far as I know, mental disease is pretty much about pleading guilty. But I mean, it goes to intent. So I looked up mental disease. We got these different mental disease defenses: insanity, and the defendant was unable to understand. I think the cops were insane. The cops had diminished capacity too. Their mental states were impaired to the extent that they could not form the specific intent required for the offense. They just kind of went off of feelings. So I think the mental part is also something to be concerned about with the cops as well. I mean, it's not just the defendant involved with using their minds. There were multiple minds, multiple brains used in this scenario. So you don't just default assume the cops' mental state were bad. You don't assume this cop's mental state was good either. And Davis talked about how he was at a morgue before he went to the library. So he was looking at dead bodies with his partner, and then they come to arrest me. So they had dead bodies on their minds before they come to arrest me. So what's that going to do? It might give them a little PTSD. I mean, I don't think they went to look at the dead bodies at the morgue as part of something routine. I think they did that for fun, because he talked about training her. It was a big training day for Favors, Davis and Favors, because he mentioned that he asked her if she's ever arrested anybody like this or whatever, and she said no. So he was guiding her through it. He was giving her training on my arrest. But just like he was giving her a little training about the morgue, they were probably a little upset that they had to leave the morgue to respond to my call at noontime, which is probably an unusual time to get called anyway. And they wanted to look at the dead bodies. And I have no doubt that they probably went right back to look at those dead bodies after my call. Let's see, traumatic brain injury, intellectual disability. Yes, they have intellectual disabilities in Louisiana. Bipolar, substance-induced psychosis, anxiety. Yes, they gave me anxiety for sure. It's usually what happens with a lot of cop interactions. So that's a mental defense as part of the law. And I don't see why not. Why you shouldn't throw that in there. Say yes, there is a mental thing. So then what you'd want to do is provide an expert. So I guess that would be what the prosecutor would want. I would want the prosecutor to prove that the cops didn't have a mental disorder themselves. All right, bring in a psychologist to show that they were of sound mind. Let's see, failure to comply. So this is what I showed earlier. This is the last thing. And it's about the mistrial when they don't disclose fully the information requested. I would say that my prosecutor has failed on providing all information. I mean, look at that. They demand that the defendants provide what they know exists. And that's pretty much what I'm asking the prosecutor. What do you know exists? And he didn't disclose the library videos. And so now we got emails back and forth. And I hope my lawyer can bring this up, that this is known to exist, these library videos. They say they have been deleted, but I would ask about recovery with that. So that's it.